Hi, I'm Matt Drake of Drake US Limited. This series of podcasts concerns do-it-yourself construction adjudication. In this series, you'll hear information from Peter Vinden, the Chief Executive of the Vinden Partnership, Paul Jensen, the Principal at Paul Jensen Associates, Michael Pye, the Principal at Pye Associates, Richard Barnes, Senior Consultant of the Vinden Partnership, Kenneth Salmon, Solicitor at Slater Healis, and James Driver, Partner of the construction team at Clark Wilmot, with questions posed by myself, Matt Drake. We hope you enjoy listening. So today I'm joined by Ken Salmon, Solicitor at Slater Healis. This is episode 5 of the podcast, Do-It-Yourself Construction Adjudication. Ken, would you like to tell the listeners a little bit about yourself?
Well, thank you, Matt. Thank you, first of all, for having me. It's a pleasure to be able to do this. I have a particular interest in adjudication because I've been a construction solicitor since the mid-1980s, in fact, probably a bit earlier.
Okay.
When the ICE arbitration procedure was first introduced by John Off in 1982, I think we were the first people to use it in an adjudication, in which John Off also took part as it happened, although he wasn't the adjudicator. Mr. Hawker, Geoffrey Hawker, was the adjudicator. So I've been doing construction in one form or another since then.
Right.
And of course, adjudication is relatively new. It only came about in 1996 and didn't actually start until 1998. And at first, there were so few cases that they were fascinating and they got reported pretty fully, but not everybody saw them. So I decided it would be a good idea to digest them and do a little write-up. And at first, it was no more than a paragraph or two.
Right, okay.
And it's developed since then, so that now we've got a couple of cases every month, and we've had hundreds of cases, and the judgments get more and more sophisticated as the arguments develop, and the parties try to find ways round.
Well, we were speaking before we started recording, and you were saying that these reports, effectively, that you are doing now on the cases that are coming out of the TCC are available on the Slater Healis website.
Yes, they're available on the Slater Healis website. If you go Slater Healis Construction, you will be taken to it, and you can download copies. It was published by the CIARB until 2017, and then they decided in their...
the International Journal of Arbitration, Mediation and Dispute Management, I believe it might be called something differently before that, but that's where a lot of the work you had written was published in there, and you actually had a book published as well, which was basically all of the cases you'd written up until the early 2000s, I believe, published in a book. So everybody didn't have to keep hold of about 300 journals that they would have received from CIR. But what you've done now is it doesn't appear in the journal, but you've continued to produce those on the Slater Healis website. So people who have an interest in adjudication and want to refine their approach, for example, by learning what's gone wrong previously with other parties and hence why it's gone to enforcement, they can read these cases and read your report on them and get a better understanding of them. Would you say that's fair?
Yeah, it is, Matt. That's a pretty fair summary. And what we try to do, I'm usually assisted now. Initially, I used to do these things on my own, but now I have some assistance. But what we try to do in our reports is to highlight the main features. The factual backgrounds can be so varied and sometimes so astonishingly complicated that you almost lose the will to live before you get to the meat of the case. So we try to distill that down to the basic facts that you need to have to get an understanding of what the case is about. And we try to concentrate on the main points that the case brings out.
Basically, which is what people want. It's bite-sized information, and I think what people want now is that life is so fast-paced, people don't necessarily have the time to sit there and read a 28-page decision from the court. So it's great that you're able to summarise that and pick out the main bits and put the emphasis on what the decision was, and people can read those and become much more informed. Well, what I want to do is, you are familiar with what we've been doing in these podcasts. We've been trying to put forward a series of audio recordings so that people who are interested in adjudication, have heard of adjudication but don't necessarily know much about it, or maybe have been involved in adjudication but want to act and represent themselves. These recordings are basically so that those people can listen to them and become more informed about what to do in certain situations and what the process is like and how they should behave and perform and in meetings and so on and so forth. And this recording with yourself is about what these budding DIY adjudicators should do or should not do so as to give themselves the best opportunity of having a successful adjudication. So what I want you to do, if possible, is to take us through that process. If you're speaking out to advising somebody who wants to do an adjudication themselves, what would they need to do? And if you want to talk through your points that you've prepared, that'd be great.
Sure, and I'll take it slowly. I'm going to assume that our listeners have listened to other podcasts or have got some idea what the adjudication process is like, because it isn't my purpose today to explain the process.
Yeah.
But very basically, it is an alternative to litigation or arbitration. It is a paper process in the main, which will produce a decision which is temporarily binding on both parties and enforceable in court as well if necessary, until the matter, the issue, whatever it was, the dispute is finally decided by a judge, an arbitrator, or by the agreement of the parties. But it's a process which can be ever so simple, or appear to be ever so simple, and can become extremely complicated and sophisticated as well. But that said, there are lots of disputes where it isn't necessary to have lawyers or other kinds of representation, where parties can do it themselves. And I'm going to try and outline the things that you need to have in place, the blocks, the building blocks that need to be there, and the things that you need to try and avoid, and the accidents that can happen.
Okay. Yeah, fantastic.
So it's almost a case of adjudication. What can go wrong? Well, lots of things can go wrong, but you have control over quite a number of them. So the things that you can control that otherwise might go wrong are as follows. Let's take it before you start. This is before you've even put pen to paper. You need a contract. There needs to have been a contract for construction operations. Now, construction operations are defined in the Construction Act, I'll call it for short.
Yes.
It has a very long title, the Housing Grants, Construction and Regeneration Act of 1996, and it was amended in 2011 by the Local Democracy, Economic Development and Construction Act as well. And sitting below the Act, which gives parties two things. One is a right to interim payments when a contract is going to last more than 45 days. And it says that every contract's got to have an adequate payment mechanism.
Yes.
And the parties have got to be able to understand what sums become due and when, and the final date for the payment of those sums. So that's the first bit. And then the second bit is dispute resolution by a process which we called, or the Act has called, adjudication, which, as I say, is a decision made by an independent, neutral person, basically on paper, although he can hold a hearing if he wants, he or she can hold a hearing, which will be temporarily enforceable, temporarily binding and enforceable in court. So before you start, you need to be sure there's a contract. So a contract, I'm not going to try and define contract, but it means an agreement that you can recognise, and it doesn't have to be in writing. It can be a purely verbal agreement. So, the builder comes along and he has a look at the work, and you say to him, how much is it going to cost to put that radiator in? And he says, £200, and it will take me 3 hours. Fine. You've got a contract.
Yes.
It could be a contract that's wholly in writing. It could be a contract where there's an exchange of emails, an exchange of letters, a quotation and written acceptance. Or probably more commonly, there is some sort of order, somebody's terms and conditions.
Yes.
And it might even be a standard form of building contract, like the NEC contracts, the new engineering contracts, or a JCT type contract.
Yes.
But all of those are construction contracts, provided they are for construction operations as defined in sections 104 and 105 of the Construction Act.
Yes.
And there are exclusions, and basically the exclusions are twofold. It's certain industries that are excluded because they're regarded as sufficiently regulated not to need any help. And secondly, contracts with consumers, effectively homeowners, where you're doing work, or construction operations are being done for someone in a house which is either their home or is going to be their home. So those are excluded from the ambit of the Act, but sometimes come back in, as we'll see. So is there a contract, and is it a construction contract? You need to be satisfied that it's those things before you have a right to adjudicate, unless the contract gives you a contractual right to adjudicate, which it might do, even for non-construction operations. Let me demonstrate. Some years ago, I was asked to act for a kitchen company who are going to design and install kitchens for the West Coast mainline trains, the Bombardier trains.
Yes.
And these were either not regarded as construction operations or they were actually excluded because it was the rail industry. But we actually negotiated an agreement to adjudicate because it was felt to be useful. And it was agreed and inserted in the contract, even though it wouldn't have been there otherwise. And that is to say, the Act wouldn't have said there was a right to adjudicate. So, one, is there a construction contract? Let's assume there is. Second thing, you need to have a dispute. The cases talk about a crystallised dispute, and all that means is that the dispute has come into existence, i.e. someone has submitted an application for payment, and the other side have either not responded within the time that they should have done, or within a reasonable time, or have disputed it in some way, or have not admitted it. So that would give rise to a dispute.
Yes.
And there were lots of cases early on about what was a dispute, but it's pretty well settled now that I think a dispute could easily be recognised. So I don't think that will cause a great deal of difficulty. But starting before the dispute is crystallised is fatal.
Yeah,
so
you wouldn't start an adjudication before the final date for payment and when there's an opportunity to issue a notice of intention to pay less, for example.
Absolutely.
You would wait for that to pass and either you've not been paid the notified sum, which could be your application in default, or it could be the notified sum, or they've not paid the default notice, so they've not paid anything, and then you would go off and adjudicate because the final date for payment was passed, so to speak.
Unless, exceptionally, you get a situation where you've submitted an application for payment, and before even the date for a payment notice, the other side say, we don't recognise this as an application under the contract, it's not in accordance with the contract, we're not going to consider it and we're not going to pay it. So there's a dispute at that point.
Yes. Doesn't happen.
No, it doesn't. And people are more sophisticated than that. I mean, most employers and most main contractors will know where they stand in relation to these matters, and they'll know it's better to go through the payment notice procedure.
Yes, and issue that.
And issue the requisite notices, so as not to give the receiving party the opportunity of saying, well, I've got effectively a default situation here because I've asked for the money and they've simply not said anything and not paid it. Or rejected it out of hand with no proper notice and no explanation why. So, crystallised dispute. You can't adjudicate a dispute if the same dispute has already been adjudicated. You'd think that was obvious and wouldn't give rise to a problem, but it does. Because you might have a series of applications for payment under the contract, in fact, often will have. And if, let's say, on payment application number 2, there's an issue about whether certain variations are payable or not.
Yes.
And that goes to an adjudicator and he decides that they are payable and he assesses the value at that stage. You can't then adjudicate that point again. So you can't adjudicate on those variations. Yes. You can adjudicate on other variations or other payment applications, but not those ones.
Yes.
That's a very simple example, but sometimes it can be quite complicated. Nevertheless, that's the principle. Okay, getting the right referring party and the right responding party, in other words, correctly naming the parties when you go to adjudication, sounds obvious, but there are cases where this has not happened, and there are cases where sometimes a party has more than one name or it has a trade name.
Yes, so you're going to effectively get in company's house, get the company registration number, tie them together, get the right address. It can be a massive issue, can't it? Because you could be, as you say, adjudicating against an organisation which is the wrong organisation.
Yes, you can be. So you're right, Matt. You go to company's house. I mean, you can do this online, and you can just checking the name and the registered office doesn't cost you anything.
No.
So it's in the public domain, this information. You go to company's house online, just check the name and the registered office. Check the company number if it's on a letterhead or other document you've got. Let's make sure it's the same number. Sometimes there are a series of companies with very similar names, almost identical.
Yes.
Lots of developers, for example, do that. They have blogs 1973 Limited, 74 Limited, 75 Limited, or an address, blogs Noble Wood.
Yeah, they have to because it relates to the development where the work's taking place.
Yeah, Water World Limited or whatever. So it can be slightly confusing and it's worth checking. And obviously, you should know your own name. And so if you're a limited company, don't put, Fred Blogs, put Fred Blogs Limited. Don't forget the limited. Even though you may trade informally by using your actual name rather than the company name. So make sure you get the right parties. That's essential. The other thing is ambush, and this works both ways. So if you're the claiming party and it's Christmas Eve, well, no, it's 2 weeks before Christmas, beware actually commencing an adjudication, because you might think, well, if I go now, by the time they get the notice, they'll have closed down for the Christmas break. There'll be nobody there to deal with it. Yippee, they won't get their response in time, in accordance with the adjudicator's directions. And I might just be able to get the thing through without anyone saying anything about it. That's not probably going to work, even from your point of view. But it could also backfire in that if they do get their response in literally on Christmas Eve, you may then have to spend the whole of the Christmas holiday.
You might have 3 days for a reply, and you are up against it, aren't you?
Exactly, and you might have to respond by New Year's Eve. So if you don't want to ruin your own Christmas break or Easter break, beware doing that. So ambush is a two-way thing. If you think you can ambush the other side by getting in at a particular time, beware the fact that they may just have the resource or the nous to deal with it in time, then putting the onus back on you at a time when you haven't got the resource.
Yes, you've got to make sure you're available throughout that whole timetable, haven't you? Really?
Yes.
Don't just think, I've issued the notice and the referral and I'll just wait for 28 days, because there could be jurisdictional challenges that start. You may be given the opportunity to submit a reply. It could go on even further. You could be asked to submit more documentation or provide more information to the adjudicator. So make sure you're available for that 28-day process.
Yeah, that's a good point. And actually, just to elaborate that point very slightly, one of the things I find is useful, and it's just a tip, is that it's useful to do your referral notice, which is the document. Effectively, it's your statement of your case and the documents that go with it. It's useful to do that before you start, because otherwise what you might do is you think, well, all I've got to do is a notice of intention to adjudicate. So all I've got to do is send them a letter that says, we were in a contract, this is the contract, these are the parties to the contract, we've fallen out over this, so that's the dispute. Yeah. This is what I want. I'm going to adjudicate, and what I want is payment and a declaration, for an extension of time or something like that. And you think, well, that's all I've got to do. And you get that in, and then you'll find that within a matter of days, you're then required to serve your referral notice. And if you haven't begun to do it, you're going to find it's going to take up more time than you imagined. Yeah. And then what happens is you suddenly discover when you're doing your referral notice that there are things that you didn't put in the notice of intention to adjudicate that you really do need. And then you've got to start again.
Let the notice lapse, and then get the referral done. From that, extract the relevant points of the notice, and then you should theoretically be in a much better position than doing it notice and referral. And it is a really good point that I think to raise. And
it is a top tip. You're absolutely right. I mean, I always do the referral and then carve out the notice of intention to adjudicate from that.
I think everybody who I've spoken to during this process has said the same thing. Not necessarily it's made its way into the recordings, but they've definitely said the same thing to me. It seems for people who are actively involved in the adjudication process, either as a party rep or as an adjudicator, it's common knowledge. But to DIY adjudicators or people who are getting an interest and starting themselves, they need to listen to that as a good tip. Definitely.
I hope so. I hope it's helpful. So we've been looking at things that you can control before you even start, and things you need to be aware of and look at and make sure that you can tick all those boxes. After you start, there are things that can go wrong, but these are also things that you can control to a degree, or some of them are. So these are some of the things that can go wrong that you can watch out for and have a degree of control over. And the first one is the appointment of the adjudicator. If you have a written contract, you need to look in the contract to see if it gives you a right of adjudication and has any rules for the adjudication. One of the things that it might have is the name of an adjudicator. It might name the person or persons, there can be more than one, who will adjudicate any dispute. So they've been pre-selected by whoever wrote the contract. And these are the persons to whom you have to go. So if there's a named adjudicator, you have to go to the named adjudicator. If that person is unable to act or unwilling to act, then there'll be a fallback position, which is presumably that the contract will tell you which organisation will appoint the adjudicator. These organisations are called adjudicator nominating bodies, for short, ANBs. Yeah. And there are lots of them. And many of the standard forms of contract actually either pre-select them or give you an option. And there are names in there, common names, like RIBA, RICS, CIR, CIOB.
You can either keep them all or strike out the ones you don't want. Strike them all out and write one in, for example, that you do want.
Absolutely, you can do all those things. But with the, let's say, more formal contract, there's a good degree of likelihood that there will be a named ANB. Less likely are the named adjudicators, because there are potential problems with naming the adjudicator. Because if I'm Blogs Limited, an international contractor, and I name Mr. Smith as my adjudicator in every contract that I issue to everybody, somebody's going to start to say, Mr. Smith effectively is a tame creature of Blogs Limited. He does all their adjudications. He must be biased. So, you risk allegations of bias if you name the same adjudicator in every contract. Now, our listeners are not the people who write these contracts, but they need to be alive to that. So if there is a named adjudicator, you might want to inquire what the relationship is between the adjudicator
and the other party trying to impose the contract upon you.
Absolutely, yeah.
Yeah, that's a good point.
Yeah. So the point now that I'm making is if there's a named adjudicator, then you need to go to that named adjudicator. If there's an ANB to appoint the adjudicator, you need to go to that ANB and not some other one. If there is no named adjudicator or ANB, then you can go to any ANB to appoint the adjudicator. You can also agree an adjudicator with your opponent, but that may be a waste of your time.
Yes, they may take the time to agree on somebody and totally lose the impetus of what you were trying to do. So, yeah, and probably avoid that. If there isn't one mentioned, then go to an ANB and ask them to appoint an adjudicator for you.
To emphasise the point, though, if you go to the wrong ANB, if the contract says go to RIBA and you go to RICS and RICS appoint the adjudicator, the whole process is going to be a nullity. It will just not result in an effect.
The adjudicator has no jurisdiction.
Has no jurisdiction. There will be no decision that's enforceable. So you mustn't go to the wrong ANB. The next thing you've got control over that you want to watch is getting the appointment process right. So don't apply for the appointment of the adjudicator on the very same day that you send off your notice of adjudication. Because, although it's highly unlikely, there is a risk that the adjudicator could be appointed before the other side even get the notice. Suppose your notice has gone by post and takes 2 days to arrive, and the ANB appoints the adjudicator before it's arrived. So that probably won't happen. So probably doing it on the same day may be all right, but it was not worth the risk, so don't do that.
If you are going to do it, perhaps morning, issue the notice, late afternoon, request the appointment. So you can perhaps request a read receipt or a delivery note with the email if you're serving the notice by email, so that you can be certain that the other side have received it. You don't want to certainly not do it in the same hour. That's where you run the risk, don't you?
Yes. And also, you don't want to apply for the appointment too late, because once you've served the notice of intention to adjudicate, you need to get your referral served within 7 days, which means you need an adjudicator in place before the end of that 7 days.
Yes.
Otherwise, you've run out of time and have to start again. Clear?
Yeah, clear, yeah.
Right, okay. I have already dealt with this, the named adjudicator situation, where if you're going to ask for an adjudicator to be appointed, and you want a civil engineer, then that's fine. You can say to the ANB, please will you appoint a civil engineer? They're not bound to do that, but they may very well take notice that this is the person of the right discipline, with the right experience. But if you go to an ANB and say, I want Mr. Smith, or Mrs. Smith, then there is the risk that the other side may say, how many times have you asked for Mr. Smith to be appointed adjudicator? And how many adjudicators has he done? And you don't want to be into all that.
No. Certainly that could be picked up on by experienced party representatives. They would, why have you asked for that particular person?
Yes.
And then, avoid that.
It has happened, and there has been a case not that long ago in which the party said, how many times has this particular adjudicator been nominated and adjudicated your dispute? And it turned out there have been quite a few occasions. And it might even be, although I'm not talking about that case now, but it might even be that this adjudicator had also been privately instructed by them in connection with an adjudication, because many adjudicators have other disciplines.
Yes.
And some of them act as party representatives.
Yes, they do.
So one's got to watch that. An obvious thing is to make sure you serve the referral in time, that is within 7 days of the notice, as I've already said. But after the adjudicator's been appointed, because he'll then say, here I am, where's your notice, where's your referral?
Yes.
The service, now you touched on this, Matt, earlier when you were talking about service by email, for example. Normally you can serve your notice by any effective means. In other words, any means by which you can prove it got there.
Hand-delivered, recorded delivery, email, fax, in some ways.
Yes. All of those would be perfectly proper methods of service. But the contract might have something to say about service. And let's suppose it says all documents are to be served on Mr. So-and-so, or Mrs. So-and-so, a particular representative, at the site, not at the registered office, not the business address, on the site, handed to somebody and tied with a pink ribbon. And if that's what the contract says, that's what you've got to do.
That's what you agreed to do.
Because that's what you've agreed.
Contract. And don't fall foul on that particular. That's a point to note, isn't it? You mentioned earlier on about it becoming a complicated and sophisticated process, and all of these little points that we're going through and these checks that need to take place, so important for somebody who's been listening to these podcasts and wants to embark upon doing their own adjudication. I can imagine people now looking for a contract and seeing, what do we have to do to serve a notice? Not necessarily the notice of adjudication, but a notice, because there'll be certain clauses in contracts which particularly talk about the serving of notices and how they're to be communicated. So that's a point to check, most definitely.
Yes, it is, and it applies to payment notices and other kinds of notice of delay or whatever it is. And you also make a very good point, a general point here, which is that if it were criminal law and you were sort of, charged with drink driving or something like that, then Mr. Loophole here in Manchester, Nick Freeman,
I think that's his name.
And his firm, they specialise in going through the police procedure that's required and finding a slip-up. And effectively, that's what will happen if you adjudicate and the other side decide to instruct the equivalent of Mr. Freeman. And often they will.
Yeah.
And one of the first things the solicitor will do is go through all these points and check that you've complied with everything to the letter and dotted every I, crossed every T. And if you've not done that, they'll find the loophole and derail the adjudication.
They will do.
So you need to get these things right. One of the things that's not so obvious that one needs to be aware of is communication with the adjudicator. So the adjudicator is now on the scene. And to show that we're not being sexist, we'll say the adjudicator is Miss Rosemary Jackson, a very well-known barrister, also a mediator. She's an excellent person. And let's suppose that Rosemary's appointed and you think, I think I'll give her a call and just make sure that she got all those documents that I sent to her home address on Saturday.
Yeah.
Because it was a very tight timetable and she said I could deliver to her home. So I'll just give her a call. And while we're at it, I'll just say, what did you think about their response, Rosemary? Did you think it really sort of, went to the points that were set out in my notice?
Will we have any issues with what they've said?
Yes. Now, Rosemary is going to say, I don't think we should continue this conversation. And she will also report it to the other side. She will say that you phoned her to check that you got the documents, that you did actually ask her a question, but she declined to answer and terminated the conversation. And that's what any reasonable, decent adjudicator is bound to do. If you're not dealing with someone who's, an adjudicator who's completely alert to these points and there is some dialogue and it doesn't get to reported to the other side and it is material in some way to the merits or the process, then you could find that there's been a breach of the rules of natural justice and that the adjudicator's decision is unenforceable for that reason. And it's no use thinking the other side will never find out because these things tend to come out.
And you don't want that to run the risk and have that uncertainty. Just don't do it. And the adjudicator, they often, it's one of the main points in their introductory email about communications. Anything you send to me must be sent to the other party. They'll talk about methods of communication, whether it's via email or they want hard copies. but they will say, don't contact me. No phone calls. It's a paper-based exercise, and you must copy the other side in all the time. That's an important point to note as well, because people may think, oh, I want to make sure, as you said before, I want to make sure that they got our case, and I'll just give them a ring. And no, you can't do that. The adjudicator will acknowledge receipt of your documentation as soon as the adjudicator receives it, or is in a position to confirm the acknowledgement. So just don't do it.
No, it's not worth the risk.
No.
I have to say, I have actually done it myself when I know the adjudicator's got a secretary, and we phone the secretary to check a document that was legible, let's say, if it was sent by fax in days gone by or something like that. But that's all, and I would let the other side know I was doing it immediately, I told them. But it's not a good idea, and if the adjudicator wants to talk to you, then he will arrange a conference call or a meeting, and he'll have representatives from both parties present so everyone can hear what's going on.
Yes.
I've also added to my list an unreasonable refusal to give more time when requested. It's in the gift of the referring party to extend time for the decision to a degree. It's 14 days.
Yes, it is, yeah.
14 days. After that, if the adjudicator's really stuck because he's got so much paper that he needs to go beyond the time for the decision, and you are asked to extend the time, and you think, no, I want to pin him down. I don't want him reading all this extra stuff the other side have sent to him. Refusing could be detrimental to you in one of two ways. One is the adjudicator may say at an extreme, well, that means I haven't got time to properly consider everything, so I can't carry on with the adjudication. I'm resigning.
Does that happen often?
I've never known it happen.
Or it could happen.
But it could happen.
Yes.
And he could threaten it, which is just as bad. And you really don't want to upset the adjudicator, and you don't want him to have to make a rushed decision.
No, you want him to focus on the task at hand, don't you?
And you don't want him thinking that the only way you can win your case is if he doesn't look at the other side's case properly. But that's not good either, because that's giving the wrong impression. My case isn't very good, Mr. Adjudicator, but if you don't look at the other side's case too closely, it might get through. So we don't want any of that. So I think the answer is that as a referring party, and indeed as a responding party, it's a good idea to accommodate the adjudicator.
Yes, it is, yeah.
Now, sometimes these requests for more time don't come from the adjudicator, they come from the other side, who say, the adjudicator has given me 7 days to respond, but I really need 14. Can I have 14, please? And the adjudicator's monitoring this correspondence. You don't want to appear to be unreasonable, and why would you want to appear to shut out the other side from saying what they want to say?
Yes. It's just on that point, I think, going back to what we were talking about at the beginning, if there's a contract and that contract has particular details about adjudication, it's worth noting, because sometimes it might say what the time is for the issue of the response. So it may be that it sets out in that particular contract what it is, and that's from personal experience not so long ago where we acted as party representative. It was the CIC adjudication rules, and the adjudicator was appointed and issued a communication saying this is the timetable. I want the response within 7 days of the date of the referral. We checked through what was agreed, and it was 14 days. So we wrote back and said, actually, the agreement is that it's 14 days. The adjudicator responded and said, okay, it's 14 days. It's worth picking up on things like that, because you may put yourself into a position to respond to something within a time frame which you've actually agreed something different. You may not be able to set your case out correctly within that period as well, within the 7 days. So if you have 14 days for your response, and that's what you've agreed, and the adjudicator hasn't spotted it, bring it to the adjudicator's attention.
Matt, you make an excellent point, which is that if the contract has got rules for the conduct of the adjudication, then everything I'm saying in this chat with you is subject to those rules.
Yes.
One's always got to check the rules. So I'm assuming that you've looked at the rules and they're not going to be counter to what we're talking about.
Yes.
But if they are, then the rules prevail.
Yes.
You're absolutely right. Yeah. So where are we at? So we've got the right adjudicator, or we've gone to the right body. We've served in time. We've served at the right address and in the right way. We're not spoken to the adjudicator when we shouldn't have done. We haven't unreasonably refused to give anybody an extension of time when it was reasonably necessary. It's not really a sort of a pitfall to avoid, but it is worth saying, and I think others will probably have said it in previous podcasts, which is you've got to prove your case.
Yes. Yes.
So one of the positive things you need to do is to make sure that you've got your evidence before the adjudicator.
Yes.
Make sure you file the right evidence. There's a point that follows this, which we'll come to in a moment. In fact, I'll deal with it now, if I may, which is that what you don't want to do, this is the converse of that situation,
yes.
is start to file extra evidence, introduce different issues, or in fact enlarge the dispute after the process has started. Because technically it's the notice of adjudication that identifies the dispute, gives the adjudicator the jurisdiction to decide that dispute, and enlarging it thereafter in any way, shape or form can be fatal to the whole thing. And it's not difficult to do unless you're careful, because you could actually do it by just putting in more documents which actually start to say different things or build on the case that's already there. So it is important not just file the right evidence, but don't file stuff that actually seems to relate to a different kind of dispute.
Yes. Yes, I understand exactly what you mean. Yeah.
So if the dispute is about payment application number 4, actually introducing documents for payment applications 5, 6 and 7 might just accidentally enlarge the dispute or take it off course.
Yes, and you want to keep focused on the dispute that you've issued, you've set out in the notice to adjudicate.
Yes, absolutely so. Absolutely so. Note and keep an eye on the timetable. The one thing you want to avoid is the adjudicator issuing his decision late. And it's interesting that in cases it's now been decided that the adjudicator has until midnight on the 28th day or whatever the last day is to make his decision. And there has been a case where the adjudicator was a couple of minutes, I think it was about 5 minutes late.
I'm not sure the precise number of minutes.
It was minutes late, but the court said, well, no, that was all right. But, an hour late.
Yeah, it's different. It's
a different story. So, you don't want the adjudicator being late. So don't do things which cause him to be late.
I provide more information on the last day.
Yeah, wanting the last word after, as it were, everything's closed. Yeah. The final thing during the process that you have some control over is jurisdictional issues. We're now talking about the responding party rather than the referring party, because the referring party has said, that's the dispute, please decide it.
Yes.
If you're the responding party and you think there's some reason why the adjudicator doesn't have jurisdiction, and it could technically be a referring party as well. If the other side introduced something and you say, oh no, you've got no jurisdiction to deal with this counterclaim. So if you want to object to the adjudicator's jurisdiction, what it's essential to do is to raise your objection in writing as soon as possible. Yeah. As soon as you know that there's a point. Obviously, you can't do it before you know about it, but as soon as you know about it. And secondly, reserve your position and say, we don't think you've got jurisdiction to deal with this, so you must either resign or not deal with it, as the case may be. And our further participation in this jurisdiction is subject to that point, and we reserve the right, when it comes to enforcement, if you do go wrong, to be able to object to that part of your decision or to your decision.
Yes.
It's good practice to do that at every stage, so it doesn't appear that you've somehow decided, I no longer object. So if you do it on day one, but never mention it again when you're actually filing documents, it might be that the court would say, well, you've waived the objection.
Yeah. So this is in a situation where you are on the receiving end of the adjudication. So you're the responding party and you raise a jurisdictional challenge. The adjudicator makes a non-binding decision on his or her jurisdiction, continues. You still need to say that you disagree with that or reserve your position in all future communications regarding that jurisdictional challenge that you've raised. Is that what you
Yes, that's what I'm saying, yeah. So it's generally going to be the responding party who wants to raise a jurisdictional issue. It could theoretically also be the referring party, but let's keep it simple. It's the responding party. Yeah. You need to maintain that jurisdictional objection all the way through. And jurisdictional objections, I don't want to go into this in too much detail because it's not relevant at the moment, but it might be a general reservation. I mean, people sometimes say, we're going to take part in this adjudication, but we're going to reserve our position in relation to any jurisdictional matter that might arise, even though they don't know of one, that it hasn't arisen yet. That kind of general thing is of little value, if any, unless and until something actually does occur, and then you've got to be specific about what it is you're reserving your position on. So it is quite important to do that and to do it at each stage. So every time you communicate with the adjudicator, there should be some wording that says you're reserving your position in relation to that issue or issues. And if you were to go online and have a look at any of the judgments that are available on HM Court's website, where jurisdictional objections have been raised, you can pick up a wording that's been held to be effective, as opposed to one that hasn't.
Okay, that's good. A good tip.
Yeah. Let's move on. So we now turn to the things you can't control, but you need to be aware of, so that if things are going down the wrong path, even if you can't necessarily do something about it, you need to know that it's going wrong and consider whether there's something like, do I stop this adjudication and start again?
Yes.
Is it all going to end in tears if I don't? So what happens if the adjudicator goes off on, it's called a frolic of his own, And this sometimes happens. And an example would be that the referring party says, I'm entitled to an extension of time, and here's my evidence, an expert's report, and I've calculated it in this way, and it's for these reasons. And the other side say, well, actually, no, those didn't cause any delay, and I've got my own calculation of what caused the delay.
Yeah.
And then the adjudicator looks at both the referring party's case and the responding party's case and says, actually, I think something else caused the delay, reading the documents.
Yes.
I'm going to give them an extension, but not for the reasons they've asked for, but for something else. And that would be a frolic of his own, and that would destroy the decision. It would not be an enforceable decision.
He didn't answer the question that was asked of him, so to speak.
Quite. Well, he's not decided the dispute that was before him. He's decided another dispute.
Which wasn't referred
to him, i.e., was there a delay caused by factor X?
Yes.
Which neither party. Now, there can be situations between that where the adjudicator actually asks questions and says, look, I'm not sure about this. I want you both to tell me what you think. That's legitimate. And it's also legitimate for the adjudicator if the referring party says I'm entitled to an extension of 12 weeks and the responding party says it should be nil, the adjudicator could arrive at 6 weeks or 7 weeks. I mean, that's well within his jurisdiction to say, well, I don't agree it's the full 12 weeks, but neither is it nil.
Okay.
Procedural unfairness we've touched on, which is to say the example was, unilateral communication with the party.
Yes.
And indeed, refusal to extend time.
Yes.
When a party really needs more time. Refusal of the adjudicator to allow a party to respond to the latest submission by the other party, because there's already been five submissions.
Yes.
I've got everything I need. I don't want to hear any more. That could end up in a procedural unfairness. Going to view the site, if the site is a main contractor site and the adjudicator thinks, well, it's on my way home, and he wanders onto the site on his own and sees things that the parties don't know he's viewing, that could be a procedure. Those are kind of examples of procedural unfairness that could make the decision unenforceable. So if you think that those you may not know about them, of course, and if you don't know about them, you can't do anything about them until you find out, which might be at the enforcement stage. But if you find out about these things, then you've either got to try and correct them if they're correctable.
Yeah.
Is there such a word, correctable? If they can be corrected.
If not, you've just made it up.
And otherwise, you may have to think, this adjudicator has gone so off-piste that I'd be better abandoning this adjudication.
Would you...
Now, that's an interesting point, isn't it? I mean, can you abandon the adjudication when you're 2 days from the decision?
I don't know.
It may not be. It's maybe too late to pull it then. Unless there's an obvious mistake by the adjudicator, and you say, I'm sorry, Mr. Adjudicator, you shouldn't have done that. That now means that you can't reach a fair decision. So I'm not going to proceed.
Would you advise a party, either the referring or the responding party, to constantly bring the adjudicator's focus back onto the jurisdiction that's in the notice by making a statement which is you're only asked to decide the dispute that's referred to you in the notice? So would you say something like that?
Yes, you might very well do that. I mean, if you think the adjudicator is straying from the point, adjudicators have different ways of dealing with things. There are some adjudicators who like to submit a series of questions to the parties. And there are even some adjudicators who actually write down provisional or preliminary, not findings, but, this is where I'm going with this at the moment. Do you want to say anything about that? And that's held to be okay.
Oh, okay.
The adjudicator it's not an unfairness, because you've been giving both parties an equal opportunity to say you've got it wrong or you're straying from the point.
And it does happen where the adjudicator will say, these are what I believe to be the issues that need to be decided.
Yes.
And seek that confirmation from the parties that is what the dispute's about, so to speak. At the beginning, when we started speaking, you did say, I've already mentioned it, about it being a complicated and sophisticated process, and it's when the listeners will listen to what you've been talking about, they will drive home the importance of getting it right, because it is complicated, and ultimately, and one of the reasons we've done the podcast with you is because of your experience and understanding of what's happened in the courts from the summary judgments that have taken place, the enforcements, and you've pulled together all of the case information, and you've got a good overview of what you need to do so as to avoid even getting to that stage. Hopefully the people who have listened to the podcasts will be now much better informed than they would have been before these podcasts were out there. And one of the points that I've asked of the other interviewees is, if there was a single piece of advice, or maybe 2 or 3 pieces of advice to parties, whether or not it's in the adjudication process or to have a chance of succeeding in the adjudication process, what would you tell them? What would you advise them to do to make sure they've got it right or they've done something correctly?
Oh, that's a good question. I think probably the first thing would be read the contract.
Okay.
Assuming there's a written contract.
Yes.
If there's no written contract, then, fine, you can adjudicate, you go to whichever nominating body you would like, and you've got a free rein to a degree. If you've no contract, and you therefore don't have to read any rules that relate to it, then we come to the scheme, which we've not mentioned, have we?
No.
So under the Construction Act sits the construction scheme. So it's a scheme for construction contracts. We'd be looking at the England and Wales regulations,
yes,
but there are separate regulations for Northern Ireland and for Scotland. They're very similar. They're all very similar, but they have slight nuance differences because of terminology and so forth. But the scheme for construction contracts, England and Wales regs, which have also been amended pursuant to the 2011 Act, contain effectively the rules for adjudication, if the contract doesn't lay them down.
In Part 1.
Yes, in Part 1. And by the way, the contract has to comply with those rules. And if it doesn't, then the whole of the contract rules get kicked out and the scheme applies.
Yes.
So the default setting is the scheme. You can build on it and have extras, bells and whistles and knobs, but you can't take anything out and say, oh, we don't need that.
Yeah.
So it's all got to be there. So you can look at the scheme and it's quite readable and it's got its own little rules. So read the contract, read the scheme.
Yes.
The first piece of advice. The second piece of advice, I suppose, is this isn't now what can go wrong. This is how to win, as it were, is don't forget you've got to prove your case. So it's no use just throwing all the paper at the adjudicator and thinking, well, it's all in there somewhere.
Yeah, you can sort this out.
If you read it all, you'll surely see how badly done to I've been, and that I'm really entitled to some money, please. That won't do. You've got to show that you're entitled to it. So if there's a real issue about what the work is worth, I'm assuming we're talking about money claims. There are other kinds of claims.
Yes.
But the most common, predominantly, it's people chasing money. So you've got to prove that you're entitled to the money. If the money comes from prolongation, then you won't have to say, I am entitled to an extension of time. And if you haven't already got it, you won't have to answer for one. Yes. So prove your case is the second thing. And the third thing I would say is don't go before you're ready. In other words, have everything ready and in place before you start. And that sounds rather obvious, doesn't it? But it's not usually the case.
No, and you mentioned before about, and that ties in with getting the referral done before you issue the notice.
Because that will tell you what you need then.
Yeah, to provide.
It will make you concentrate on what the dispute really is and how you're going to prove it. Because with the referral goes all the documents that you're going to rely on.
Yeah, and you know, it's been mentioned in the other podcasts about the burden of proof in adjudication, with it being civil law, is on the balance of probabilities. We're not necessarily looking for, I suppose is it probably a variation or is it probably not a variation, but we want to be really, to give you the best chance of success, you want to be going there with something which is a bit stronger than probably a variation, don't you? You want to prove that there's a change to the scope of work, prove the cost, if there's a time impact, prove the time, perhaps provide drawings and specifications, so on and so forth. So that, and also put them in a structured way, so when the adjudicator is reading through the document, he can refer, or she can refer to the appendix evidence which you provided to support your case, and you can do that. I mean, you've got to prove your case to win, haven't you? So it's an important.
But the structure point you mentioned is quite important as well. I mean, nothing will delight an adjudicator more than seeing that as he works through the referral notice or any other submission, that the documents that are relevant or proving the point are then identified. It's page number whatever in the bundle.
Yeah.
Brilliant. I can turn straight to it. I don't have to go searching through
and also,
one of those 57 lever arch files.
Well, you want to tell them, if that was the case, effectively what file it would be in as well. And it's good to keep the referral or the response, or whichever part of document you've written, you're supposed to keep it separate from the appendices, because then the adjudicator can be reading one copy in one file and can flick in another file, rather than moving the referral ahead and then going behind it to all of the dividers and finding the correct appendix. Keep them in separate, not all of the appendices, but keep your appendices in separate files so the adjudicator can flip between the files and correlate what the person's reading to the evidence that you're relying on as well.
Yeah.
Just a little thing like that, I suppose, is useful. I think, Ken, that we've come to the end of the podcast, unless there's anything else you wanted to add, but I think you've been really thorough with what you've said there, and you've made and raised several really good points, which, if taken on board by people representing themselves in adjudication, should hopefully avoid ultimately the adjudication not falling at the first hurdle or falling at somewhere in the process. But unless you've got anything else to add, I think we can draw this interview to a close.
Thank you very much indeed. I would just say this to parties embarking on adjudication without representation. It sounds more scary than it is. I mean, it's more scary because I've just been pointing out what goes wrong. It's like going into hospital, to have your bunion removed and somebody giving you a list of all the risks. Well, most of these risks do not materialise, let me tell you, in most adjudications, but they do from time to time, and they've all happened at some time or another.
Which is based on your experience from your work as a solicitor and party rep, but also what you've read has gone on in all of these cases you've reported on in many ways, and you've put them down, haven't you, and talked through them today.
So don't be frightened to have a go. Use those points as a sort of points of the compass to keep you on the right course. If something goes wrong and you're unhappy, or something's going wrong, or you're not sure what to do, you can always take advice on that point. It doesn't mean you've then got to hand the whole case off to somebody else. Yeah. You may be able to get advice on a single point.
Yeah.
And that can be quite a cost-effective way of doing things.
Definitely, and some of the other interviewees have said the same thing.
I'm very happy to have been able to have this chat with you, and I hope it's useful to your listeners.
It will be, definitely, Ken. It will be. Appreciate it very much.
Thank you.